Three judges in the U.S. First Circuit Court of Appeals heard oral arguments today in the appeal of the federal convictions of fraud and corruption of former Fall River Mayor Jasiel Correia. Correia is currently serving a 6-year sentence in federal prison in New Hampshire for defrauding investors of his Snow Owl app company and seeking payments from potential recreational marijuana vendors in exchange for a favorable recommendation from state regulators. He was convicted during a federal trial in May of last year. Attorney Stephen Sabra of Sabra Law says the format of the oral arguments before Judges Sandra Lynch, Bruce Sala, and Jeffrey Howard is limited to each side having only 15 minutes to prove their cases.
15 minutes for each side is really not very much, but those are the rules. So if you're arguing the case as an appellate attorney, you basically, in general, maybe get a few sentences out, and usually it's questions, because the judges already have all the briefs. They have your brief, they have the prosecution's brief, so they start with questions, and generally they take turns. Although sometimes one judge might ask more than others. It would be a panel of 3 judges that would ask the questions, and it's kind of rapid fire from there. So you have to know your case. You have to know the case law, and pretty hard to predict what the questions are going to be. So you've just got to be fairly quick on your feet.
Attorney Sabra says much of what the judges will consider lies in the pages of briefs submitted by Correia's attorneys and prosecutors in the U.S. Attorney's Office.
The briefs are they 20 pages long plus exhibits or longer? So. But there might be conflicts, there might be new cases that the judges are curious about. So you can persuade a judge in an oral argument. More so, I suppose, I would say in the trial court level than in the appellate level. Mostly, it's going to be what's in the briefs and what the case law requires. But sometimes, when the judges are looking at the briefs, there'll be certain questions that they don't feel have been answered to their satisfaction, or they might sort of propose hypotheticals, which you see a lot from the U.S. Supreme Court. So,
in his court briefings, Correia's attorneys are arguing that, among other things, there should have been separate trials for both the Snow Owl and marijuana cases, and that U.S. District Court Judge Douglas Woodlock provided conflicting instructions prior to jury deliberations. Attorney Sabra says during the oral arguments, it's rare for the judges to tip their hands on how they may rule.
Even if you're attending one of these hearings, you can't really tell which way the case is going to go from the questions or the comments from the judges. Sometimes the questions you might feel that it's leaning a certain way, but the decision can go a different way. So it's very hard to tell, even if you were present for this, exactly what the ruling was going to be, unless the questions are clear from at least two of the judges that they're really going in a certain direction. And the issues are going to be the same as really what's been argued all along.
Even though today's court appearance was brief, when a judgment will be rendered is entirely within the purview of the 3 judges.
The timeline is generally going to be 3 or 4 months. Might be a little shorter, might be a little longer, but that would be, I think, a fair estimate. They're going to convene and talk about the case, and then it's kind of like we know about the U.S. Supreme Court, right? They talk about the case. Someone's assigned to do a draft opinion. The draft opinion circulated around. That's supposed to be all confidential. But as we saw with the U.S. Supreme Court, maybe it wasn't in one very famous case recently. But and then they come up with their final written opinion.